Does your license need saving? Do the wise thing. Call Wise Man Lawyers. Does your license need saving? Do the wise thing. Call Wise Man Lawyers. Don't face that court alone. Let the Wise Man team get you back on the road. Does your license need saving? Do the wise thing. Call the Wise Man team at Wise Man Lawyers.
All right, today I'm at Ipswich Magistrates Court. Client was charged with two offences, one being mid-range drink driving, the other being drive without due care and attention, otherwise known as careless driving. Short version is he was driving a Tesla, which for those who don't know is an electric vehicle. They've got quite a touchy accelerator and they're known to accelerate quite quickly and silently. He'd recently bought this vehicle, attended a dinner party, had some drinks at the party. He thought he'd paced himself, and guests at the party were pressuring him to show them the safety features of this new Tesla vehicle. In his words, he's basically fobbed them off, and as the evening wore on, I guess the peer pressure became too much, and he's agreed to basically drive around the block to show one of these guests the features of this vehicle and how it can pull up quite quickly and that kind of stuff. Whilst he was doing this, he was seen to be basically stopping in the middle of the road and then taking off at speed, exceeding the speed limit quite dramatically, stopping, and the police observed him to be exceeding the speed limit by quite a bit. He was intercepted, breathalyzed, found to be mid-range. He's quite a successful, I won't go into too much detail, but he's a successful person in his field and quite wealthy, so even though technically he was eligible to apply for a work licence, we would never have been able to get over the severe financial hardship hurdle. To get or to be eligible to apply for a work licence, you need to be able to prove that you're going to suffer severe financial hardship. And if you're a successful business person and your wife's a successful business person, and you're driving a Tesla, you're going to struggle to prove that you're going to suffer severe financial hardship if you lose your licence. So for those reasons, we didn't apply for a work licence. But then further compounding the eligibility was the fact that in addition to drink driving, he was also charged with careless driving, which again makes it difficult to convince a magistrate that you are a fit and proper person to be granted a work licence. But in any event, he didn't want a work licence because he wasn't going to be able to prove the financial hardship. So my job was to firstly try to get the disqualifications down as low as possible, but more importantly in his mind was the recording of convictions for both offences. He's Indian, he's a permanent resident, he has he intends to apply in the future for citizenship, and for that reason, the fact that in his particular profession there's ongoing renewals of professional registrations, etc. He was concerned about the recording of convictions. So, as I said, concerned about the impact it would have on future citizenship applications and the ongoing registration of his professional qualifications. Short version is I drafted very lengthy and detailed written submissions on the recording of a conviction. I mean, it's one thing going in trying to get no conviction recorded on a single drink driving charge, but it's entirely different trying to get it on a single drink driving charge and a single careless driving charge. As I said, there's question marks all over it when it comes to whether or not you deserve to have no convictions recorded. My client has had his version of events, the police had their version, and obviously we pled guilty to a mutual understanding, but both parties had their own, in their minds, more elevated versions. I'm starting to prattle on a bit now, but what I'm getting at is to get no conviction recorded, I couldn't just go in there and say, oh, give me no conviction recorded. The magistrate needs substantive justification to exercise that discretion on both the offences, the drink driving and the careless driving. So as I said, detailed written submissions of case law. I submitted documentation from the relevant professional body that he's a member of, showing that it may impact upon his future registrations. I tendered information sort of pointing the magistrate towards the fact that it may impact on any future citizenship application. And obviously I made substantive submissions with regard to the disqualification itself. Worst case scenario for drink driving mid-range is 12 months. Worst case scenario for careless driving is a lifetime loss of licence. There's a general discretion in the Penalties and Sentences Act allowing magistrates to give a lifetime disqualification for any offence, and that's where the lifetime disqualification potential comes in for the careless driving. So technically faced a lifetime disqualification. I made substantive submissions. As I said, the issues that were hurting us were the reading. It was quite high, mid-range. He was driving in a careless manner, speeding, and in the minds of the police, acting in a manner which was careless towards other motorists. I made submissions about the difficulties he'll suffer in his role, notwithstanding the fact that at the end of the day he can afford to catch taxis and Ubers everywhere. Because that's the thing, when it comes to trying to get the disqualification down as low as possible, I can only labour the financial hardship element so far if it's not legitimate. I mean, if you drive a $200,000 Tesla, I can only labour that point so far. Whereas if you're a truck driver, it goes without saying that you're going to suffer hardship. So while it's not easy in that instance to make those submissions, it's not near on impossible as it is when you're trying to convince a magistrate that someone who drives a $200,000 car is going to suffer severe financial hardship if they're off the road for a few months. In any event, I made substantive submissions. I was successful on both charges in persuading the magistrate not to record convictions. So no recorded conviction for the drink driving, no recorded conviction for the careless driving. I was able to get the disqualification down to 6 months. That's combined. So it was basically 3 for the drink driving, 3 for the careless driving. So a total of 6 months for the offences themselves, which, while it's not the mandatory minimum, I'm quite pleased with given the circumstances of the offending. But again, this was less about getting the disqualification down, more about getting no conviction recorded. So yeah, no conviction recorded for both charges, 6 months total disqualification, moderate fine, client's happy. I'm Andrew Wiseman, thanks for watching. Hi, I'm Andrew Wiseman from Wiseman Lawyers, Queensland's only truly dedicated drug, alcohol and traffic offence law firm. If you face loss of licence, loss of vehicle imprisonment or anything in between at any court in Queensland, we can and will help you today. This is our specialty. This is all we do. Give us a call, 1300 947 352. I look forward to helping you resolve your issue today.
Don't face that court alone. Let the wise man